Good evening, everybody. Hope you're all doing well. Today is October 29th, 2025. We have about 2 more months to go in the year. Where I'm at in Atlanta, it's finally started to get cool. We had a very rainy week. So I hope where you're at, it is not too cold, and hopefully the weather's good. Obviously, there's a lot of crazy stuff going on with the terrible hurricane in Jamaica and Cuba, and certainly all those folks. We hope that they are surviving. This looked like just a monster storm. It looks like it's going to go out to sea on the east coast. It's not going to hit any place in the United States, but anybody in the path of something like that, or anybody who was in Jamaica or in Cuba, visiting, hopefully they took cover, because that's just a monster storm. I think there's actually another storm out in Hawaii as well. So this is the season. So if you're traveling any place where there might be a storm, definitely keep an eye on the weather. Wasn't here last week, as you probably all know. I was on a brief vacation. I played tennis. Believe it or not, look at me. I do play tennis. Actually, not terrible, but I have several buddies of mine, and we go down every year. One of my friends, his family lives down there, and we go to Miramar Beach in Florida, play tennis for 3 or 4 days, eat pizza, ice cream, cookies, without being under the watchful eyes of our spouses. And it's always a nice time. So I just felt like, rather than try to do a live stream in a condo where my buddies are watching TV and just being distracting, I just said, let me just take the week off. This morning, or actually early this afternoon, I was on Stephanie Joy's podcast, or not podcast, or live stream. I know some of you probably caught that. Christina, who's one of my regulars here, was on that. I know, and a couple other people, I think, that were on that. So we had a nice time with that. And, Stephanie Joy, she's been on my live stream several times. We're good friends. We talk about things. And the nice thing about this business is it's not so much competitive as it is people want to help each other, because we're all kind of struggling to convince Social Security to do the right thing by our clients. And it's nice to have a group of attorneys that I've become friendly with, that we all kind of work together and help each other out when we can. So I certainly encourage anybody, if you haven't seen Stephanie's work, she comes from a little different approach than me, but that's cool. Walter Knott's another guy who is very, very active. Michael Liner. So all those people, if you're interested in Social Security, definitely check them out, because you'll learn a lot of different things. So anyway, let's kind of get to our topics, or our questions that we've got. Christina, good morning. It's not good morning here. It's 8:30 at night here in Atlanta. I guess when you put this up, it was the morning, and I know I saw you at this afternoon at Steph's live stream. But good to see you, and thank you very much for your support, and encouraging people to share this, and to like and subscribe. I really appreciate that. P. Brown. Long haul. I think you were on this morning in Steph's live stream as well. Looks familiar. Long haul Lyme for many years, followed the same primary doc for 7 years, had to stop. Your 32-hour-a-week job, missing too much time. He stated no work at all. Is this a med source statement? How much weight does it carry? 59 arthritis, THR, body aches, migraines, brain fog, sacroiliitis, L5S1, medical records, mostly complaints and treating symptoms. And then very worried, case has been moved to Virginia. So couple of things just off the top is, I think when a doctor writes a letter saying my patient can't work, that's not really what you want. I mean, it doesn't hurt, but the doctor is not a vocational expert. The doctor needs to explain why you can't work. Is it because of fatigue? Is it because of pain? Is it because of brain fog? So really the why needs to be kind of addressed in there. Yes, it helps if the doctor makes that conclusion, but that's not typically enough to get you where you want to go. I think you need a little bit more than that. But you have records, and I think that what I have found in long or extended Lyme cases, I've had a few of those, that what you're dealing with is there's really no way to cure it. I mean, basically, it's an infection. If you get antibiotics really quickly, many times they can knock it out, but once it kind of embeds itself in your cells, very, very hard to get rid of it. So many times what's going on is doctors are giving you various types of treatments, sometimes non-traditional treatment. And what the record often shows is that these treatments really have not worked. And so your reporting of the symptoms is certainly good evidence. The doctor's notes that he or she has tried XYZ, hasn't really worked. um, that can be very helpful. I think a pain diary or a symptom diary can be helpful. Statements from other people that know you, and it can be family. It'd be better to be maybe former coworkers. You said you're working 32 hours that can talk about the problems you are having. I would also tell you that there are clinics in various places around the country that treat Lyme disease. And I had a case, I remember, out of Virginia, actually, a number of years ago, where my client had gone to a Lyme specialist. And I'm not sure if he actually visited her or um, I'm trying to remember the name of it. If you email me, I'll give you the name of that person, the specialist. The bottom line is, um, he, I think, had the records sent to her. She offered some suggestions. I think part of this, kind of like what we used to do in fibromyalgia cases, the people that are searching for some sort of treatment, that search, the effort they make trying to find a solution or some sort of resolution, that is good evidence. It shows you're really trying. And so I think, symptom journals, evidence that the treatments the doctors have given you are not really working. These are all things that I think would help build your case. But a conclusory statement from the doctor that you can't work, probably not enough. I think you're going to need more than that. But I think a long treatment history can really go a long way. And the symptoms you've got certainly can be work preclusive if you've got migraines and brain fog. But again, quantify it. How often do you have the migraines? How severe are they? Keep a pain diary. Brain fog. The back issues, is that related to the Lyme disease or is that an orthopedic problem? So, I think you can build a case like that. But, that's what they're going to look for, is kind of what Social Security calls a longitudinal treatment record. And no question that the state agencies are not going to find that compelling. They're looking for listing level cases with objective evidence. You don't have that, but judges many times will be more open to it. I think that when the case is assigned to a judge, look up that judge to see what the approval rate is, to see if the judge is open to that kind of thing. If you have an attorney, what your attorney could do, and I do this all the time, I get on the NOSCR listserv and I'll say, what does somebody know about Judge XYZ? And it can be very helpful to sort of know the best way to present it. But that's how I would approach it. Again, the medical is what the medical is. And Lyme cases, there is no MRI or X-ray or CT that can identify it. But if it's confirmed by blood tests that you have the Lyme blood factors, then that's certainly one thing. And then again, the symptoms would be really the big way to prove it. But I've had good results. I've had several Lyme cases. I've had pretty good results with them because I think the main thing is the doctor's records show extensive efforts to find some sort of a treatment. And ideally, if you can get a Lyme specialist, that can go a long way as well. So I wish you the best with that. It also helps, by the way, you're 59. There's a built-in bias in Social Security for people over 55. So at 59, I'm not sure, maybe you could figure a grid rule argument in there, but even if not, they recognize that at 59, it's going to be very hard for you to adapt to a job. You had the job, and I think that works in your favor as well. You had a 32-hour per week job. It shows you're motivated to work despite discomfort, and you worked as long as you could. That factor comes into play. So I think all those things, will hopefully come back in your favor. Hopefully you get a reasonable judge who recognizes that diseases like Lyme, while they cannot be objectively imaged, are very, very real. And again, they are subject to blood testing, so you can prove that it does exist. So I would be optimistic based on just the little you've told me here. I think you've got a pretty decent argument if you build the case properly. Ancient ones, 28 years old, which right there is going to be an issue, I'll tell you. Diagnosed schizoaffective disorder, bipolar type with multiple failed work attempts, documented medical history, documented proof of psychiatric hospitalizations, treatment plan What else can help your claim? I think anybody who's 28, that's an issue because Social Security, they resist approving people in their 20s. There's a trust fund out there that in 10 years will be exhausted unless Congress steps in and does something, i.e., raises taxes or changes the rules in terms of what percentage of your income gets withheld or what the limits are. But yeah, it's going to be difficult. On the other hand, mental health issues do not, they're not really a function of age. Back problems, you can certainly say a 59-year-old is likely to have a more difficult time with back problems than a 28-year-old. 28-year-old with mental health diagnosed schizoaffective disorder, bipolar type, that's really not a function of age. And so, those cases can be winners. You've got multiple failed work attempts. That shows you've tried to work. I think if you could get statements from former coworkers or supervisors setting out specific issues they saw you having with your work, whether it was difficulty maintaining attention, concentration, focus, difficulty interacting with coworkers, supervisors, or the public. It's just really anything you can get from a former coworker, supervisor, that would help. If your psychiatrist will complete a functional capacity evaluation that will identify work preclusive limitations, again, attention, focus, concentration, behaving in an emotionally stable manner, getting through the workday without distractions, schizoaffective disorder, many times, there could be sometimes hallucinations, those type of things. So I think, having a really strong ongoing treatment record from your doctor, if you have support in the form of a functional capacity evaluation, that can go a long way. Statements from third parties, maybe a symptom diary you can talk about, or maybe if you can't keep one, if there's somebody in your life, a parent, a spouse, a friend, a sibling, can maybe create a symptom diary that they can talk about what they observe. Because I know it's hard sometimes when you're in the middle of this to recognize, okay, I'm having a really bad day, I'm acting in a strange way, and to you it's normal. So it's hard to really know that it's an issue, but sometimes a third party would know. And those type of non-medical statements can really do a lot of good. So I think the big things would be, again, a functional capacity evaluation from a treating psychiatrist. I think third-party statements, especially from former coworkers, and maybe symptom journal observations from third parties that could talk about what they observe and the issues you're having. I think those things would certainly give you an edge. Again, uphill battle because you're 28, but on the other hand, these symptoms are not things that are age determinate. It's just something that's going to happen if you've got it. And the other thing I would tell you is, many times judges are looking. You mentioned, I think, inpatient hospitalization. They look for multiple failed medication trials. So if the doctor's given you a certain medication, it didn't work, you got switched to something else, that shows that you're medication resistant. That can be an important factor too. So if that's applicable, that would be something to focus on, that medications they've increased the dosages, they've tried different things, nothing has really helped, and maybe the side effects are extremely debilitating on their own as well. So all those type of things, just it's painting a picture. I think when I'm doing a brief for any case, but especially when it's mental health, I'm painting a picture of how the symptoms, how the treatment protocols all impact my client's ability to be reliable, to function reliably. And I think if you can get that going, that would really improve your odds. I wish you the best. It's I'm sure very difficult to deal with this, and I know those who've not struggled with mental health issues. It's hard to really understand how difficult it can be when you wake up, you don't know how you're going to feel any particular day. Cynthia, how are you doing, Cynthia? I hope you are doing well as well. I appreciate you tuning in. Okay, and this is back to P. Brown, who was asking, I believe, about the Lyme disease. 2 sets of records. Yeah, I would say, and you have the portal, which is going to be basically your records, but you're correct. Social Security will request the actual underlying records. You'll be able to get that, certainly if you have an attorney. Now we're able to get those pretty early on, but certainly when you request a hearing, those records will become available to you. If you're doing this on your own, which is not a good idea generally, you can ask them for a CD that has all the records in it, or a PDF file that has all the records in it. If that doesn't work, you have an attorney, they can download that and send you a copy, and you can see what's exactly in the records. But usually the portal records are pretty close. Just the format is going to be a little bit different. Social Security, by the way, prefers the actual records as opposed to the portal records. But if you have to give them the portal records, you give them the portal records. Peter says, recently won my disability case after 4 years of worrying about auxiliaries. Do I get them all the way back to my approval date, or does it only go back? No, it goes back to, well, let's back up. There's a lot of misconceptions about this. When you apply, let's say you applied in March of 2022, and you alleged an onset date of 2018, you can only get paid 1 year prior to your date of application. And you factor in the 5-month waiting period, or 5 full months, add another 6 months to that. So really it's about 18 months that you can allege an onset date to max out your benefits. But when you get approved, if it's 3 years from now, you don't just get 1 year back, you go back 1 year prior to your application date, assuming the onset date is, matches up with that. So if you get benefits going back 4 years, your auxiliaries would get benefits going back 4 years. A lot of people think, well, I applied 3 years ago, alleged an onset date 4 years ago. I went to a hearing in 2025. I only get past due benefits 2024. No, you get them back to 1 year, up to 1 year prior to your date of application, or your onset date, whichever is later. Not just 1 year. You don't get punished because Social Security is so backlogged, is my point. So you can do the calculations based on your date of application, date of onset. And in fact, when you get your payment letter, your notice of payments, it will tell you the month that you were found disabled, the 5-month waiting period, and when you first become eligible for benefits, and your auxiliaries get those same benefits. And it's obviously a percentage, doesn't come off of what you get. It's a calculation, typically 25%, could be depending on how many auxiliaries you have, of your benefits. So that'll be in addition to what you get, but it's the same amount of back pay, or duration of back pay. That's a better way to put it. An essay is talking about the portals, and I think what we're talking about is when you request records from a portal, the formatting is going to be different than the records if somebody requested them directly from the doctor. In my experience, the information is about the same. It's just there's one called Lucy, for example, and it has like a little graphic of a woman named Lucy. And sometimes the portal will have a picture of the doctor or your picture or something like that, or it may have added in there a bunch of stuff about, how to prepare for a colonoscopy or whatever it may be. It's just kind of supplemental stuff that's more relevant to you as the patient, as opposed to actual medical records. But the actual medical records are in there. I don't know that portals are going to delete things or simplify things. It's just there's extra stuff in there that can just, it takes up extra space and takes more time to go through it. But I don't, I've never had I shouldn't say never. Only once or twice has a judge said to me, I really prefer not to get portal records. I know when I had an adjudicator on a few weeks ago, she went by Linda, if you want to look it up on a prior live stream. That's not her real name, but she went by Linda. And she said, when we request records, we prefer to get the actual records as opposed to the portal records. And I get that because it's easier to read and easier to zip through. But if you can't get the actual records, or what I find sometimes is that medical providers will use copy services like Ciox is one, where they want to charge a lot of money for medical records. And the reason they do that is that if you're a lawyer doing personal injury work or workers' comp, there is a way where you can pay for records and spend $300, $400, $500 in records and get reimbursed, because a check comes to your law firm that's made payable to you and your client, and you just, okay, there's a case cost, let's reduce, let me reimburse myself, and then the rest of it goes to you as the client. Social Security doesn't work that way. They just pay a check to you, or deposit to you, and a deposit to me. So if I've absorbed $100 or $200 in medical record costs, there's really no way for me to get it back unless my client voluntarily pays it. And to be honest with you, that's been an issue. People don't want to pay it. So I just found that what I do is, and we've had a lot of success with this. We'll get portal records. We'll get or we'll ask Social Security to request the records. And there's a system now called the HIT, or Health Information Technology, where they can get the records instantaneously. So 20 years ago, getting medical records was a real hassle, because you'd have to fight the copy services that wanted to charge for it. They want to get paid up front. There are some states where there's no charge for records if you're pursuing disability. Other states allow 10 cents a page or 50 cents a page, all this type of stuff. That problem has really gone away, between portals and HIT, and there's other ways to get them. It really is not a problem anymore. And again, what I try to do in my practice is, at the initial and recon stage, I notify Social Security that these records are out there. Please get them. In fact, if you ever received an email from my office, if you're a client, or even sometimes from me, on every email I send out, or certainly that my paralegal would send out, there's a link. Have you seen a new doctor? You have a new medication. It goes to a form you can fill out, and we use that, and we ask Social Security to request the medical records and let them do the work at the initial and recon. And if it's at a hearing, we can contact the hearing office and say, use the Health Information Technology service to get those records. So it's not as big of a deal. So between HIT and the portals, it's just it just really is not a big issue. So, but if worst comes to worst and you have to submit portal records, submit portal records. I've had many cases. I'd probably say most of my cases have portal records in there. So that's no problem at all. All right, choice. For hearing in January, my state approved me for a PCW. Not sure what a PCW is. Let me just see. Let's see if I can figure it out. PCW. No, that doesn't make any sense. I don't know what PCW is. PCW, I'll just say abbreviation. Personal care worker, maybe. That may be what you're talking about. I'm guessing that's probably what you're talking about. And for those, if you're not familiar with that, is in some states, you can ask for what they call personal care worker. This is a person who comes to your house daily, 2 or 3 times a week, kind of like a social worker in a way, but they will help you with basic activities of daily living, whether it's cooking, cleaning, personal care, bathing, things like that, going to the grocery store. And it's obviously a indication of somebody with problems handling daily activities. I think just like a handicap placard, it is evidence that you have been found to be disabled at some level. But the definition of the level of disability you need to have a personal care worker is not the same definition as Social Security has. Certainly, there was evidence that was submitted to the state to qualify you for a personal care worker. What evidence was that? Maybe find out what the standard was for qualifying, and put that information in the record, so that even though it's not binding on the judge, clearly states are not in the business of paying for a personal care worker for somebody who's not significantly disabled, limited in some fashion. Again, it doesn't win your case, but it's certainly a factor, just like a handicap placard is a factor that somebody made a decision, but there had to be some medical behind it. So I think if you find out what the standard is to qualify for a personal care worker, and what the medical that was used to make that determination, that all needs to be in your record. And that situation would help your case. Remember, you don't win disability on a diagnosis. You don't win because you have a personal care worker. You don't win because you have a handicap placard. You don't win because you're a VA 100% disabled. You win because the medical evidence shows Social Security you meet its standard for disability, which is vocational, which means that you have to prove that you don't have the capacity to be a reliable employee at anything, Although again, at age 50, that can change a little bit with the grid rules, but basically that you don't have the capacity to be a reliable worker. That is what you're trying to prove. And so any other finding of disability that uses any different definition or even the same definition is not going to be binding on Social Security. They make an independent determination. Cynthia says, please hit the like button. Yes, please hit that like button. I like to have the likes. Woody says, email Jen today. Jen is my paralegal, sent to my email address. Hopefully you got it. Hoping to hear from you. You have that case. I have objective evidence. I look at everything, and I will tell you today, I was focused on, I've got a couple of briefs for hearings next week that I was focusing on today. I also, Wednesday is the day I spend half my day watching my granddaughter. Which I love doing. So Wednesdays are not as productive. And I also was on the podcast, on Stephanie's podcast. I keep saying podcast, on her live stream for an hour and a half too. I didn't get a lot. I got some work done early in the morning, but I didn't really respond a lot to emails during the day. So probably going to look at that tomorrow, whether it's Jen or somebody. I've called screeners that could look at it. Madeline and Angela can look at it. So we'll definitely get a response to you. CWA, I will be 55 by the time you're eligible hearing. If a lawyer went to a CE, a consultative evaluation, the examiner said patient has significant limitations. I have 2 surgeons who want to operate. Let's see. My question is, since you filed November of 24, is that when I turn 55, I may not get back pay? Yeah, that is a risk. I think that I've seen more and more judges do this where if you've just turned 55, it's really easy for them to say, yeah, we're going to find that you're limited to no more than light work. You meet the grid at 202.06 or 202.04, whatever. And we're going to find you disabled and there'll be no back pay. When I have a situation where my client has just turned 55, I will address that in the brief. That I recognize they just turned 55, but we are making a strong argument that disability actually began at 53 or whatever you were at the time of your onset, and here's why. And if it's a grid rule argument, that you're limited to sedentary work, and again, if you've got medical evidence to that effect, that's what you argue. And realize when I mentioned grid rule argument, you can argue in the alternative. You can say, and that means you can say, I believe I'm disabled under the grid rules, but in the alternative, I believe that my functional capacity has been so reduced that I wouldn't be able to do any kind of work. Typically, it goes the opposite way. So you start to say, I can't do any kind of work at all. I would be too off task. I'd be missing too many days from work. I can't focus, concentrate. I'm just not reliable. In the alternative, if I do have some capacity, I'm limited to, 50 to 55, I'm limited to sedentary work. I have no transferable skills. I therefore meet the grids. If you're 55, in addition, if I'm 55, even if I'm limited to light work, grid 202.06 applies. So I think you can make alternate arguments to say, I'm totally disabled. I can't do anything at all. But even if I have capacity, it's not enough to get past the requirements of the grid rules. So it's always going to be a challenge because I'm finding more and more, both at the administrative level and at hearings, judges are doing this where they're moving the onset date forward. Many times they will say, would you consider, and they'll say to your lawyer, have you talked to your client about possibly amending the onset date? I would talk to your lawyer about it. And if you're not willing to do it, make it clear, no, not willing to do that. We realize this might come up. We discussed it. We feel like the evidence is very compelling that disability began at age 53, and we're not willing to concede that the person, something changed, or that their capacity, that they would meet they're limited to the light grid rule. We think sedentary is more appropriate. The judge always has the option of issuing a partially favorable decision, and do you appeal that? But I've also had judges back down. If you say, yeah, we talked about it, we made the decision, we're not going to go with that. And some judges will say, okay, I can live with that. I think many, if you're new at this and the judge says, would you change the onset date, you might be inclined to say yes. And look, I will tell you, there have been cases where I look at the evidence and I think, I tell my client, the judge is going to look at this. The evidence really is more compelling, as of 55 to limit you to light work. If the judge suggests it, I would probably tell you to take it. A bird in the hand's worth two in the bush. You'd be giving up your past due benefits, but you'd rather have something than nothing. So it's going to be a case by case kind of analysis, is what I would say. Papa's Place. Hello, how are you doing? Papa's Place says hello to everybody. Thank you. Kristen Hendricks got approved last Friday. That's great. A lot of people ask me, has the government shutdown, has that limited approvals and limited what's going on? Not really. I mean, I'm not seeing any real change in my business, at least. I'm still getting hearing decisions, administrative approvals, cases being processed. So I think, the problems are going to be at the field offices where somebody needs a social security card, or where somebody needs, I understand fee petitions are not being looked at. So there's certain peripheral things where that's being hurt, but I think, case evaluations are not really being affected very much. So that's a good thing, at least for now. Maria Rivera. Maria, hello, how are you doing? Okay, I think we just talked about that. Christy, hey, Christy, you missed me. I had a good time. Yeah, we went down there, and it was beautiful weather. It was about 75, 78 degrees every day and sunny. Found some clay courts. All two of my friends in particular, one of them just had knee surgery. One of them has a sore Achilles. So playing on clay certainly made it a lot easier. Clay courts were they weren't great shape, but it was still fun to be out there. It's nice. I tell everybody, no matter where you are in your life, take a vacation, take a few days off periodically, just recharge the batteries. Even if it means just taking they call it a staycation, just at home, just do something different. You don't have to spend a lot of money, find a pool and go hang out by the pool at the Y. Just anything to kind of do something a little bit different. You'll find just that it's just always very helpful. And I've been really busy the last couple of years, really. But it's important because you get burned out with anything when you're working 6-7 days a week. So yeah, it's important to do that. And I try to do something every couple of months, even just for a couple of days, maybe taking a Friday and a Monday off, 4-day weekend. But try to do it when you can, because if you don't do it, no one's gonna offer it for you. All right, Kelly Maynor. Hello, Kelly. How are you doing from South Carolina? I'm guessing you are getting some of this cold weather we're getting here in Atlanta. It was actually rain. I got back from Florida on Sunday morning. It was kind of drizzly by Sunday afternoon, and then Monday, Tuesday, today, raining and cold, like 48 and rainy, pretty miserable. I think tomorrow is supposed to be sunny. And it'll be cooler here. We've got a cold front coming in, but if it's sunny, I don't really care as much. But it's just that cold, wet, cold. That I'm not a big fan of. Christian says, "Hello, Maria." Hello, Christian. Congratulations, Papa Place says. Okay. Amazing Grace Ranch. My daughter is 31 and has severe anxiety and migraines. What would her chances be since she's so young? Where would she start to apply? Well, first of all, I would suggest that you have her get a My Social Security Statement, ssa.gov/my account. That way you can see what her benefit would be. And that's a starting point. And does she have enough credits, earnings credits? If she's just short on earnings credits, try to work another year to get the extra 4 credits. And I wish they would tell you how close you are. You can do the calculations, and it's a little, if you want to learn how to do it, I probably need to do a video on that, but you can see how close she might be. Let's assume she's got enough earnings credits to qualify for SSDI, and the benefit amount is $2,000 a month or something that would make it somewhat worthwhile, I guess. I think that 31 is going to be an uphill battle. I mean, anxiety and migraines are both kind of invisible illnesses. You can't really take an MRI image of migraines or anxiety. It's going to rely on the medical records. At a minimum, she would need, ongoing treatment and strong support from her psychiatrist. She would need probably evidence of failed medication trials for the migraines. If there's a headache clinic near you, I found that to be an effective way because they are trained to look for people who are malingering or exaggerating. They have all the different things that can be tried, the prophylactic medications, the ones that limit the headache, Botox, anything like Botox. So I think that would be helpful. So if you have treatment at a migraine specialist that has not been effective, multiple failed medication trials, you've got ongoing treatment records from a psychiatrist and support from the psychiatrist in the form of a functional capacity evaluation. Yes, she's young. Those factors might be enough. If you throw in statements from former coworkers that talk about the problems she had when she was working, that can make it stronger. But there's nothing you can do about being 31, and that is always going to be an issue. But, I've won cases for younger individuals. I will just tell you that there's a subset of judges out there who just aren't going to pay the case if you're under 50 or under 45, certainly. And so you get the wrong judge, doesn't matter what evidence you've got, it's going to be an uphill battle. But as far as where to start, go to ssa.gov/apply for disability, and that walks you through the process. But the first thing I would do is get the My Social Security statement. Papa's Place is in North Carolina, 3 months in the process, don't look for the long wait. Yeah, I hear you. I mean, it's not good. I mean, I'm trying cases now where people applied 2.5 years ago. So you have to assume it's going to take a couple of years. Very, very difficult to survive without any, having money coming in. Okay. Glad you mentioned Walter. Could I talk about the new reporting system for those who are also working or receiving disability? Got a letter. I don't know enough about it to really comment. I know that I believe it's through the My Social Security portal where you can now report your earnings. I don't know whether or not there's any sort of a automated system that would tell you when you report it, hey, you've used up your trial work period months, or you're over SGA, you're at risk of being, reviewed or terminated. I think it's just a way to give them information at this point. It would be a lot more helpful if you would get real-time reporting back that would tell you that you've used up your trial work periods, or again, that you've your work is over SGA, but that's not there yet. This is just reporting. So I don't know that there's much other than, and I haven't seen it, so I don't want to discuss what it actually looks like. I know that the Social Security is using a representative availability portal that I use to say when I'm available. It's got to be done 6 months in advance. So I just did the one today for April, my availability for hearings in April, and that reporting portal, or that availability portal, is not the most how do I put this? Is not all that well designed, in my opinion. It is a little bit confusing. Doesn't have a lot of instruction. In fact, I wanted to put in that a couple of days I wanted to be available from 1:30 on, 1:30 to 4 or whatever. I couldn't do it in the morning because I had something, in the morning in April. And I've been trying to do half days for several months. I couldn't figure out how to do it. So I actually got Stephanie Joy on the phone or on a Zoom call, and she showed me how to do it. And there's actually a step when you put the information in, you have to hit a button and press it, and it records it and it shows you. And it's not clear you had to do that. So now I see how you do it. And so it worked. And then you also have to hit, when you're ready to submit, you have to submit, but it doesn't give you a screen that says you've successfully submitted. So you don't know did they get their information. So I'm guessing the portal for reporting earnings may be kind of the same, as they don't necessarily tell you it's been received, or if they're missing something, or what it all means. I'll see if I can find more about that. But at least it's a way for you to kind of give them information in real time. I still say that you need to keep your own records, and you have to kind of know when you've reached your trial work period limits, or you've reached substantial gainful activity, and you may be putting yourself in overpay status. It would be nice if that was done electronically, but I don't believe it is at this point. But that is, something that they're new, and this is really reflective of what Social Security is trying to do, is to automate more things, use AI for more purposes. I know that Linda, the employee, told me that there's an AI program that adjudicators can use, but it's really clunky. It doesn't always work. That's going to get improved over time. And my guess would be that as part of there's been some talk about changing the rules to make it more difficult, make the grid rules, move them forward a couple of years, or even eliminate them altogether so that fewer people qualify. There's going to get to a point 5 years from now, maybe, where Social Security can use AI and all the data they've got at their disposal to determine which cases are likely to be approved and therefore fast-tracked. And so what that means is cases that are turned down have already been analyzed by an AI tool that presumably incorporates a lot of knowledge on the part of Social Security. It's going to be harder to for attorneys to make a living doing this because there'll be fewer cases to litigate. I think you're going to find the cases there'll probably be more early approvals, which benefits Social Security because they don't have to pay as much past due benefits, and they get the people that are clearly deserving. On the other hand, I think part of what they try to do with all the long delays is to discourage people, so that may go away. But then you're going to have the cases that do go to hearing. Right now, the average approval is like 50%, 49%. That may go down to 30% because I think that those cases won't be as strong. So there's going to be some changes here. What that all means when it all comes down, I don't know. But I think that they're definitely going to try to use more AI tools to evaluate claims. Because honestly, when I'm looking at a potential client case evaluation comes by email, my AI tools right up here. I've done this a long time. I know I can just usually tell by looking at what somebody says, the tone they use, the information they provide. I have usually a pretty good idea whether it's a viable case or not. Not always right. And sometimes when we talk to them, it turns out that they are not as viable as I thought. There have been a few that, have slipped through the cracks that probably would have been good cases that I referred out to somebody else, let's say, and they won. And I'm like, well, good for them. But, it might be a case I could have taken, but, it didn't meet my criteria at the time. So, what's in my brain, if that can be put into an AI tool, could be pretty useful in determining, what cases should be approved or not. What that will mean in terms of the practice day to day, what other roles attorneys will have, I don't know. But there's going to be some changes, and I know Commissioner Bizignano is a real believer in AI tools, and so I suspect we're going to see more of that. What's going to happen if ACA, I guess the exchange healthcare expires? I don't think it will. I think that there's right now a lot of discussion, amongst Congress people. I think as soon as one political party decides it's too much of a liability to have the government shut down, they'll cave on some of these issues. I don't know. We'll see. I don't expect it to go away. Could it be modified? Possibly. But I don't know. We're just going to have to see. Pat says, what do I think? And Pat, we'll be talking. We just talked yesterday, right? What about supportive letter from a supervisor or coworker for your case? Yeah, those are always helpful. Always helpful because this is a person without a dog in the fight, to coin a phrase, and they can talk about what they observed in a work environment. And in that situation, work environment is what Social Security is all about. So if you've got somebody who, can speak to what they saw in a work situation, that's always going to be very, very helpful because that's the real issue here. And I think, that can be useful. Medical records, for if you've had 5, 7, 8, 10 surgeries, for example, medical records can be really compelling as well. You may not need the extra stuff, but anytime you have things that you can put in the record that reflect a different angle to your disability, that's always helpful, I would say. Golfer. My wife won her case. Do you think they ever shut down? No, I don't think so. I think that part of things has not really slowed down, my experience. Khalil, thank you very much, Khalil. I appreciate it. Jennifer, getting ready for a hearing on December 19th. Very nervous about my hearing. A lot of medical issues worsen. A lot of medical documents to support. I upload to the portals. I go to doctor visits. Yeah, that's what you want to do. I was in the hospital, 11 days cervical neck surgery. Lupus result in the blood test. I'm seeing a rheumatologist. Yeah, all these things, what I would say to you is this, is that any evidence that discusses a significant medical problem that would interfere with your ability to work, we can argue the cumulative effect, the combined effect of those things, would disable you, would make you less dependable and reliable. I also have to balance, I don't necessarily want a lot of recent stuff. I mean, anything that's medical has got to come out, I got to put it in. But in terms of my argument, I don't want to really focus so much on recent things because I don't want to lose past due benefits for you. So, I would argue many times that some of these things that have gone on, the surgeries, the more recent treatment, or the diagnosis is something that have existed 2, 3, 4 years ago. It's now come to a head. You finally got, insurance to pay for the surgery, or you finally got a diagnosis. I had somebody email me today, one of my clients, we just tried his case. I think we're going to win. Good, solid case. And he said to me, I just got diagnosed with Lyme disease. That kind of explains some of the symptoms. Should we put that in? And of course, now the case is in ready to be written. So I don't think it makes sense to necessarily do it. The record's closed. We could possibly use it on an appeal if we needed to. I don't think we'll need to because we're going to win. But, I think that there's a balance. You've got to put everything in. But what do I focus on in my argument? I want to show that the condition existed at a disabling level 2 years ago, 3 years ago. I don't want to, a win's a win, but I don't want the judge to approve you, Jennifer, and say you became disabled November 1 of 2025. That would be, again, that would get you ongoing benefits, but, that would cut out your past due benefits. And, you want to get that money, you deserve it. And so that's where I've got to be when I write my briefs. I'm always kind of aware that I want to describe recently diagnosed things as sort of the, as part of an ongoing problem that has been going on for, months or years. But don't be nervous. We'll be just fine. Hello to you, Bala 2001. Tom is scheduled for, I think you mean ALJ, not AGJ. ALJ hearing in Philadelphia, city of brotherly love, on January 30th with a judge below average. How far below average? I mean, if it's, my experience has been, and this is just very, very, back of the envelope talking. The average is right now, I think the last waterfall chart I saw was maybe 48, 49%, which is right at 50, right by 50%, let's say. If you have a judge that's 47%, 43%, that's not going to concern me too much. They're still approving a lot of cases. They may be a little more picky than other judges, but they're not unreasonable. You get below 40%, you're in the 30s or the 20s. That's what gets me concerned. And I know, Chad Brown is a friend of mine, another attorney. I think he did a video about this, and he said, a judge that is approving in the 30% range is going into the hearing with the idea that he's going to deny you. You got to prove otherwise. A judge going in with an approval rate of 60%, he's assuming he's going to pay it unless you show him reason otherwise. So I think that's one question of how far below it is. The average, what is the percentage? And check a couple of sources. There's more than one source. If the judge has only tried 15 cases and his approval rate's 35%, not enough of a sample size. If he's done this for 15 years and it's consistently at 30%, that's more of a problem. I would tell you that even low-paid judges will approve cases. There's a judge here in Atlanta who's like in 31, 32%. He awarded a case of mine a couple of months ago without even a hearing. He awarded it on the record. I about fell off my chair, but he did. So, anything can really happen. I think if you're over 50 or especially over 55, even the low paid judges, are going to be a little more reasonable. Where you get into real trouble is if you're 28 years old with a bad back and maybe some bipolar disorder and maybe eczema, let's just say, and you've got a 30% judge, and again, you're 28 years old, that's going to be where the problem is going to be really. But if you're over 55, it's less of a concern to me. And you know what? Two other things. One is I go to every hearing expecting I'm going to be dealing with the judge that has been assigned. I've had hearings, I'd say once or twice a year, I go in and the judge that was assigned is not the judge who is at the hearing. And many times it's a judge with a higher approval rate. So I have to go in every case assuming I may have a different judge. Even, I've got a hearing coming up next week with a judge in the 70% approval rate, which is great. What happens if she has a sick day and somebody else comes in who's 50% or 30%? I got to be ready, which I will be. So, that's just a point to make. You may not get that judge, number one. Number two is that even if you get the judge, even low-paid judges approve. If they're approving 30%, that means 3 out of 10 are getting approved. So you want to do everything you can to be one of those 3 out of 10. And I will tell you, being prepared, having your attorney being really prepared, that can go a long way. I had a hearing earlier this week with a judge who really does not have a very good reputation. I mean, I put a note on the listserv, what does anybody know about such and such? Or actually, I didn't put a note. I did a search, and other people had put what do we think of this judge? And 3 or 4 people, oh, she's terrible. She doesn't know what she's doing. She denied a case with a person with terminal cancer, all these terrible things. Well, I'd had a previous case. I keep notes on all the judges. So anytime I try a case, I keep notes on the judge. I had a previous case with this judge, and my notes were, client was very, very nervous. The judge was very compassionate, went out of her way to make my client feel comfortable, approved the case. Sounds pretty reasonable. At the hearing, the judge was not on her game, I will tell you. I mean, she was asking things that didn't make a lot of sense. And she was coughing and hacking a lot. Maybe she wasn't feeling well. I felt like some of the questions at the vocational level didn't make a lot of sense to me. So, I tried to be very diplomatic. And when I had a chance to ask the questions, I kind of brought in some of the things that, I wanted to make sure were on the record. I'll give an example. One of the things was my client had a previous unfavorable decision. And let's say the date on that previous unfavorable was February 9th, 2023. I just pick a date. That's not the date, but let's say it was. And the claimant reapplied and used February 5th, 2023 as her onset date. Well, the problem there is that you cannot, when you lose at a hearing, you don't appeal it, that becomes what is called res judicata. And so you cannot be awarded benefits prior to the date of the unfavorable decision. So in this case, this hypothetical, the earliest my client or a claimant in that situation could get approved would be February 10th of 2023. The prior unfavorable February 9th, person put February 5th, but the reality is February 10th has got to be the earliest date. So I made sure to put on the record that, the real onset date has got to be February 10th or whatever the date was. Because if the judge awarded the case and used February 5th, that's going to get kicked back and cause, problems. And I don't want that to happen. The second thing was that my client at 55 or close to 55, there's something called the borderline age rule, which says that if you are close to a threshold birth date, like you're 54 years and 11 months or 49 years and 10 months, for Social Security purposes, they treat you like you're the next, you're that 55 or 50 or 60, whatever the age would be, which would impact the grid rules. And the judge didn't seem to know what I was talking about. And I gave her the citation for it, But again, this is something that a judge should know. Maybe she was having a bad day. But again, my experience with her has always been pretty good. I think she did a fair hearing. She was reasonable. But, it just shows she was missing a couple of things I thought that I was surprised at. My experience with her has been good. I hope that we'll get a good result here, but you just never know what you're going to get. So even judges that are low-paid judges may be feeling good one day. And again, I've had that happen many times where a judge has a low pay rate and I have a case and I'm thinking, this is really questionable. And I get in there and the judge is hearing last 10 minutes and they approve it. I remember the first time that happened to me, I hate to be telling you all these war stories. There was a judge in Atlanta. This is going back 30 years, probably a long, long time, Judge Wheeler. He's long since retired. And he was one of the more difficult judges in Atlanta, downtown Atlanta. And, every case I'd had with him, he pretty much turned down. Everybody had that experience. So I had a hearing with him with a client who was younger, probably in her 40s. And the issue was swelling. She had lymphedema. She had swelling in her body. And there was really no specific cause for it. It was basically an idiopathic lymphedema, meaning that she had swelling, but they couldn't figure out why. So I'm thinking, great, I got a really tough judge with an idiopathic condition and it's swelling. We get in there and the hearing took about 10 minutes. He's like, well, I can see how, this terrible swelling would really impact you and make it really hard. You can't really focus and concentrate. He's asking all these questions. You can't remember things, can you? You're having to take a lot of time off. He was like making my case for me. And he awarded that case in about 15 minutes. And I'm thinking, again, it was just a boggle my mind. The only thing I can think is that he or somebody in his family had lymphedema and knows how uncomfortable it can be, this terrible swelling. He approved the case. You just don't know. You don't know. I've also had judges with 70% approval rates that give my client an incredibly hard time. Just don't know. So I would not, I think it's relevant to know what the judge's approval rate is, but that is by no means something that should stop you from pursuing your case or assuming anything that you're going to lose. Just be prepared. Tell the truth. Focus on the specific problems that make you not a good or a reliable employee, and be specific in terms of how long you can do certain things and the specific reasons you can't, kneel, crouch, crawl. You can't sit, stand, walk for more than 10 or 15 minutes. You have to take unscheduled rest breaks of 20 to 30 minutes twice a day. Those are the things you want to focus on, not rather than worrying about the judge. Can't control the judge, so just focus on what you can control. Do I think that, Ken asks, do I think Social Security will remove the age consideration in the future? Stephanie and I were talking about that today. We don't know. I mean, nobody really knows. In the blogosphere in the Social Security world, there's a lot of doom and gloom. Stephanie brought up a good point. She's like, what they might do is right now the grid started at age 50. Maybe they move them where they start at 52. So the grid for sedentary is 52 to 57, and then the grid for light is 57 to 62. So they carve a couple of years out of it. They'll still be there, but it's just more difficult to win because you have the age categories to move forward. That's something that I think is pretty possible. More likely that would be something they would do because it kind of goes on with raising the retirement age. I also read in one article that before they can do this, and they're thinking, this person wrote this article, we're looking at 1.5 years, 2 years before anything comes down. Long time in American politics. But that they would have to come up with a better vocational resource than the Dictionary of Occupational Titles. You've heard me talk about this. Right now, Social Security uses a resource called the Dictionary of Occupational Titles, or the DOT. You can look at it at occupationalinfo.org. And it was last updated in 1993. And so, a lot of jobs in the DOT don't exist anymore. It's pretty useless. And so what Social Security did was to address that, because people were starting to challenge it in federal court. And I think some of the, basically what the federal court judges have been doing is saying, well, we recognize the DOT is not accurate. It's the best that we've got right now. And they send the cases back and say, well, have the vocational witness talk about all the resources they used and the methodology. And so now if you go to any hearing, every judge asks these questions to the vocational witness. How did you get information? How do you, what are the sources you used? There's the DOT, there's selected characteristics of occupation, or the SCO, there's Skill Trend, Job Browser Pro, all these things. And they ask them, what you used. And they do this to basically, satisfy the courts that the vocational witness are using, reasonable methodology. Would that stand up to a more, to a really thorough evaluation? I don't think Social Security wants to find out. So they're putting Band-Aids on the problem. But at some point, I got to think that somebody's going to raise a case that's going to get picked up by a circuit court, the Third Circuit, Fourth Circuit, Ninth Circuit, whatever, where they say, look, using a 25, 30-year-old resource is inherently inaccurate. And the reality is that the DOT codes a job. Like, let's say, for example, a, ticket taker at a movie theater might be DOT code 201.653-050. I'm just making it up. And that's a sedentary, unskilled job. Well, the newer information, like the selected characteristics of occupations, they don't use the same job titles as the DOT. And so there may be, in any DOT code, there may be 5 or 10 SCO codes, or maybe it's the other way around. My point is that they put a real Band-Aid on this. The reality is nobody really knows how many jobs actually exist. And, nobody knows what a real unskilled job is. I mean, I give this example all the time. There's a job in the DOT, copy machine operator. And basically in 1993, that meant you walked up to a copy machine, took a piece of paper, slapped it on the glass, hit a button, made a copy, brought it back to whomever you want to make a copy for. Well, nowadays, and I can speak from personal experience because I have a copier, we don't copy as much as we scan. So now if somebody's making a scan, if I had a person in my office doing that, they would have to go to the copy machine, pick a destination, or enter it into the copy machine, whether it's an email or a box on our server, scan the document, then go to the email or go to a computer terminal and then download that document, or at least grab it and rename it and put it someplace else, and maybe then delete the document off the email. Well, there's 5 or 6 steps my point. And an unskilled job is one that somebody can come off the street. So let's say you had a person, who has a 10th grade education from Ecuador, or from Poland or whatever, doesn't speak much English, and your job, they say the job is make photocopies. Okay, you don't have to speak English, you don't have to have much of an education, just make photocopies. Well, you're going to ask that person who doesn't speak English to go to a computer terminal and navigate a directory structure in Windows or an Apple, figure out a file name, rename it under a naming convention like we do. My office will name files, let's say I open a file today, 2025-10-29- letter to Judge Smith or something like that. There's naming that you can't, if you're somebody who doesn't speak English as a first language, doesn't have reading and writing skills, you can't do that. That's not an unskilled job. That's a semi-skilled job, because you have to have computer skills. You've got to be able to manage understand file naming conventions. So that's an example of a job that is unskilled in the DOT, but it's really not unskilled. And there's plenty of jobs like that. There's an attorney named Larry Rolfing who has his blog, if you ever check it out, it's I think the California Social Security Attorney or Disability Attorney blog. Just look up Larry Rolfing if you want to see it. ROL, I think ROLFING. And anyway, he goes and he spends a lot of time on his blog talking about how to challenge vocational witnesses and the inaccuracy of many much vocational testimony. And, his approach is to aggressively cross-examine vocational witnesses to document that they don't know what they're talking about. Now, I don't go with that. I'm not a believer in that for two reasons. One is that I think the main reason is the judges don't like it when you really aggressively go after a vocational witness. And secondly, is time. I mean, you have hearings that last 45 minutes. To do a really, thorough cross-examination of a VE that you might do in a criminal case, let's say, could take a half hour, 45 minutes. Judges aren't going to stand for that. And like I said, I think Social Security's put enough of a Band-Aid on this where they can get past it. Now there will come a point where, a person like Larry or somebody who follows his approach might very well get a case, a really good test case, take it up to a circuit court, and get some law that basically eliminates the DOT from any consideration or eliminates sort of this patchwork of expertise that vocational witnesses are talking about. The case might have to end up going to the Supreme Court because if you have difference in circuits. We're not quite there yet, but that's something that could happen. I think Social Security is aware of it. I think they have tried it for many years to come up with an alternative source. It doesn't exist. Whether there's money, or the desire to do that, I don't know. Whether they can, jury rig one of the existing sources like the SCO, Job Browser Pros, Skill Train, all that stuff. I don't know, but I mean, it's being held together with Scotch tape and glue. I mean, it's really, a real, the right judge with the right case would throw the whole thing out. Now that would create utter chaos because now Social Security would have no way of making decisions on vocational capacity. I think that's the concern is that, do you want to put a stop to all hearings for, a couple of years until they come up with something? But if you look at some of the decisions and, Adriana De La Torre, who has been on this live stream before, if you haven't heard of her, she's got a great LinkedIn profile. She will, post evaluations of cases, and she's really good at reading between the lines. And I suspect that, it'd be interesting to hear from her if she's getting the sense that some of these judges are getting a little tired of Social Security's, kind of using these somewhat bogus resources and kind of implying that there's going to come a point where they're going to be called to the carpet on it. So maybe a question I'll ask her. I don't know. But that's my take on it. So I know I've gone off on a very, very tangent there, but Ken asked the question. So yeah, the answer is I think there will probably be some changes that will not be beneficial to claimants, but I think they're going to have to come up with a much more robust vocational resource to determine, who the types of jobs that exist and who can do them. All right, Mary Malosky, Dr. Ed Weir is very good. Ed is not a Social Security attorney. He's a former adjudicator. He's got a I think it's a YouTube channel. I think he's like My Government Expert or something like that. He may be a lawyer, I don't know, but I've talked to Ed a couple of times. But he does a lot of videos, and he, I know at one point he wasn't charging for it. People could call him up and ask him. I'm sure he gets really, really busy, but he ran like one of the busiest Social Security offices. So he knows a lot of the ins and outs of what's going on. And so, yeah, he's a great resource. I've referred people to him. He and I've spoken a few times. I probably need to get him on the live stream, but he is a wealth of knowledge about Social Security disability and all things Social Security. And I think he in his retirement just wants to help. So he's a good man. Good man. Okay. All right, Jennifer, I think I'm going through some of this stuff there. Christina says hello again. Hello, Christina. Rip the Tina. Okay, why isn't the standard decision? We consider factors such as medication, dosage, and side effects. The decision ALJ doesn't mention. Well, I mean, I think that if you were denied on that, the judge can consider factors that he or she thinks are relevant. And, they're supposed to consider that. I don't know if it's reversible error if the judge does not address those specific things. They can't address everything. But, if you made the argument that medication side effects are disabling, example, if you take Lasix, which is a diuretic and it makes you urinate every, 30 to 45 minutes, um, if that was not addressed and you've been on Lasix for 3 years, I think that would be something you could appeal on, because you could certainly say that, being on Lasix, I have urination issues, and the judge doesn't have to believe you go every 30 minutes, but he certainly, or she, would not be able to say you don't have more frequent urination than somebody who's not on Lasix. So, I think that you want to look carefully, and you raise actually a very good point. Sometimes the appealable issues in a decision are not what the judge says, but what the judge doesn't say. Um, and I'll give you an example. I just did a case, had a hearing on a case that was originally went to another judge. It was denied, and the decision, it went to district court, federal district court, and I co-counsel with Carl Osterhout on that, and kudos to Carl for his really good work on that. The reversible error was that in the decision, the judge found that my client was limited to occasional handling, fingering, and I forget what it was, fine motor manipulation. In the hypothetical to the vocational witness, the judge used the word frequent and said, Mr. Vocational Witness, assume an individual who's limited to frequent handling, touching, and feeling. Well, the judge had made a decision, finding that it's occasional, but the hypothetical said frequent. That is reversible error. That's reversible error. And so, and I may be conflating a couple of cases, but in one of these decisions, the district court says, we can't say that the judge's case ought to be approved, but we find it hard, or the judge, I find it hard to believe that a judge would find this person not disabled given the extent of the medical information. So you have a district court saying, I'm not going to tell you what to do, but hint, hint, approve this case. And sure enough, this is actually a different case, not that the hands fingering, but it was a different issue. But the point is that district courts will go in sometimes and say, you need to approve this case. And they can't force the judge to do it, but they're sending a pretty clear message. But yeah, there are grounds for appeal. If, again, one of those things you're talking about, dosage changes or side effects, were well documented and would be at a disabling level. So yeah, I think absolutely that would be something to look at if you got an unfavorable decision. Okay. How long does it typically take to complete a CDR? Is currently a slowdown? I think there is a slowdown with them. I've not seen anything official on that, but I think that that's probably an area that would be slowed down. It can take 4 to 8 months. They may send you the form and then they request medical records, just like they would at initial recon. They have to make an evaluation. It's going to be 4 to 8 months. I would tell you that's kind of probably longer, probably longer now because the back of the government shutdown. The Dreamers Club. Approved by ALJ in September. Great. Got my back pay. First payment. Great. Thanks for your help. You're welcome. Channel helping. Great. With severe emphysema on oxygen 24/7. I don't think you're going to have a CDR. That's listing level. If you're on oxygen, severe emphysema, they're not going to review you. And if they do, it won't go anywhere. I mean, that's not a condition that, unless you get a lung transplant, that's not going to be a condition that resolves. So I would not, wouldn't worry about it at all. You're not going to get reviewed. RIP, I think we saw that personal care worker, not care worker. Okay. Student account, disabilities. You're right. I think you're right. And I think that is a point. I mean, I think I read where the highest disability that you could get, if you'd earned millions of dollars a year, given the wage cap on Social Security, the highest you're going to get is $4,000 a month, which is like $48,000 a year. And even if it's not mostly not taxable, not a ton of money in today's economy. Most of the cases I see, people are $1,800 to $2,500, maybe a little bit more than that an occasion. not a lot of money. People aren't getting rich on disability, which is another reason why, it just strikes me as so odd that people in Congress feel like people are ripping off the system, to get $20,000 a year. Yeah, it's $20,000 a year, but you can't really live on that. I mean, it's really hard to live on that. Not usually you can't, but it's really hard. I think most people, in my experiences, would much rather be working and making more money. So I agree, it's not enough. P. Brown, one of my clients. Good. I'm glad they've been helpful. We are, I tell you, we have a lot of cases, and we have a system, and I tell my clients, it's let the system work. We've done this, we know what we're doing. We've done this for a long time. Nothing happens very quickly. And, I've really tried to set up a system of my practice where, we give updates. I also have, one person in particular who, if somebody is sort of in crisis and they just need to talk to somebody about what struggles are in, I've got somebody that's really good to help with that, because sometimes they just need to hear from myself or somebody in my office that we're on it. These cases take a long time, and a lot of times there's nothing going on. I'll be straight up with you. We can't force Social Security to process your case faster. And I also can tell you that, certain things are just not that big of a deal. I mean, if you completed a form and you misspelled a word on it, or if you misstated something about you put that you have a ninth grade education when in fact it's 11th grade, we can fix that stuff later. There's certain things to get worked up about and certain things not. And I know people are really anxious, and they have no money coming in, they're struggling, and they want it all 100% perfect. And there's a lot of paper being shuffled around. So, we're pretty good about doing this correctly. I had a case last week where the client had an unusual name. My assistant misspelled her name. It's not going to make a bit of difference. We'll get it fixed. We'll just send Social Security a letter saying the correct spelling is this. But yeah, it's frustrating when that sort of thing happens. But we're not perfect, but we have a pretty good system, and our track record is really pretty good. We're winning most of our cases because it just works through the system. We have a way to, we have ways to, to encourage Social Security to get medical records. We can get them if they can't. Jen does a really nice job in making sure the files are ready for hearing. I'm prepared for my hearings. So, we let the system work. So I'm glad you've had a good experience so far, and hopefully we'll continue. Cynthia says, Chris, congratulations. A lot of C's there. Congratulations, Christian. Okay. If a specialist tries, SA says, a specialist tries a medication for a month and discontinues, not being effective, this will be in your medical records, and that's add the medication to your extras link. Due to not being current, I think that that information is usually something that would be in the medical record. And, when I'm doing my brief, I'm looking at, the medical records, and I show that a medication has been discontinued. And that's something I talk about with my client. And you should let us know that you've tried multiple medications and they've been discontinued because the side effects are too bad or they don't work. That is a relevant factor. That means your condition might be medication resistant to some degree. A lot of depression cases are medication resistant. There's 5 or 6 antidepressants that are tried, nothing works. So yeah, that can be a really important factor. And that won't necessarily be on your medication list. In fact, it wouldn't necessarily even be a bad idea to put it on a medication list and mark discontinued because ineffective. And that way you're making sure the judge knows that. It's actually a good idea. That may be something that, I'd actually toyed with this at one point I was using my own medication form where we were doing stuff like that. Then we kind of got back to the habit of using their form, but that may be something to include on there, is if the client has had medications that are not effective, to have a statement to that effect, because that's, I think, very, very relevant evidence. Okay. So I just learned something. I thought of something because of this really, I think, very smart question. Thank you, SA. I appreciate that. That's actually an idea that I think could be valuable to people. Jim Biggs. Very interesting question, Jim. When I explain my disabilities with job applications, I'm denied the jobs. Okay. And this is, I think, why this is important, in my opinion, is this is the reality of the job market. You go out there, you're 53 years old, and you've got 4 herniated discs, and you can't lift more than 20 pounds. And you're sitting there in a job application, you're saying, you know, Mr. Potential Boss, I have chronic back issues. I'm fine as long as I don't lift more than 10 or 15 pounds, 20 pounds max. I want you to be aware of that. And of course, they're not going to give you that job. That's not the issue in a disability case. The issue is, if you had the job, could you perform it? So that what you're talking about is the reality of getting a job. In theory, the employment laws in the United States say that they're not supposed to ask you about medical problems until after you've been approved for your job. And then they can say, are there anything about about your medical condition that will prevent you from doing this kind of job? And that way, the Americans with Disabilities Act says, assuming they fall under that number of workers and so forth, that they can't then terminate you because you can't do the job because of certain medical reasons. However, if somebody is interviewing and they walk in there and you're limping, or you have a big back brace on, or you have carpal tunnel braces, they're going to see. And they can't really ask about it, or maybe you bring it up because you just felt like you need to bring it up, which that's a whole different issue about what you should say in a job interview. But if they find out, but that unfortunately is the reality of life, but it's not what Social Security is concerned about. Their point is, if do you have the capacity to do it? Not whether would somebody hire you. And I think there's a disconnect there, because the reality is that you're going to have a hard time getting hired with chronic medical problems. And in fact, the grid rules are designed to address that very issue. They recognize that a 55-year-old who's limited to light work because of physical limitations, and the grids only apply to physical problems, that such a person would not be able to find work in reality. But, it doesn't apply when you're 48. It doesn't apply if you have mental health conditions. It probably should, but it doesn't. So, you just have to realize what Social Security is asking for. So I would say to Jim, and I'm not an employment specialist, but it may be where, the issue of your medical issues, your disabilities, would probably be something I would not bring up. Maybe you find somebody who can give you advice about what to say in a job interview and not to bring it up. If you're bringing it up without, being prompted, I would probably tell you to stop doing that. If it's an obvious problem because you're walking with a limp, or you have a brace or something like that, there's nothing you can do about that. They're going to see it, and they're not going to say that's why they're not hiring you, but that's the reality of it. So, but the important thing to know is the standard is not, nobody would hire me. I'm clearly disabled. Nobody's going to hire me. The standard is, if you were hired, could you perform the job reliably? Vince from Michigan. Hello, Vince. Hope you're doing well. Nadira Singh is 61 years old. I'm not sure if Nadira has, oh, here we go. 61-year-old New Yorker. Diagnosed with spinal stenosis, MRI, treating the pain doctor, received a statement, unable to function, work independently and consistent due to brain fog and severe fatigue, gabapentin. Now, I think you've got a good case. You're 61, you're on gabapentin, which will give you GABA brain, is what they call it. Neurontin, gabapentin, the same thing. You've got diagnosed medical problems, brain fog, severe fatigue. I think that's a pretty strong case. Again, I hadn't looked at the medical record, but that would be a case that would be one I'm like, yeah, I'll take that case. That's a pretty solid case. You got a pretty strong grid rule argument there, in my opinion. So that's a good solid case, I think. Appreciate you. My pleasure, Amazing Grace Ranch. There's no way for an applicant to see what adjudicators are gathering medical records. To my knowledge, yes, I can see it because I can log into your exhibit file and I can see what's going on. I don't think you can. Do you think SSA is aware that we don't always have control of when or how often we get our medical appointments? We've mentioned most monthly appointments. Sometimes that can't happen. Very good point, Jim. I think that this is an issue that Social Security, look, I've made the comment before that if you don't have medical records, that's basically Social Security sees absence of medical records means absence of problem, absence of symptoms. That's obviously not the case. That doesn't always, I can't tell you how many times I look at a record and somebody was recommended for surgery and it's been a year and they haven't had it because insurance won't pay for it. That's a very common thing. Insurance may not pay for you to see the doctor every month. Are they aware of it? Probably. Do they care? No. I mean, they just look at that. They sort of look at it like, we know that not everybody's going to be able to go to the doctor of their choice every month, but you got to get to the doctor enough to establish a record to show that you're disabled. Do they know that community health centers, are not ideal as far as getting diagnosis, treatment, and medical source statements? Yep. Are they aware that the VA uses a different standard for disability and that the VA many times over medicates and doesn't generate records that can be particularly helpful? They're aware of it, but their position is we got to work with what we got to work with, and we've got to have enough evidence to convince our adjudicators that you meet that threshold. And so in many cases, the requirements of Social Security are an unfair barrier given the reality of insurance and money and the way people live in the real world. I hate to say they don't care, but they don't care. Or if they care, they have not changed anything. And to be fair, it would be very hard to change something. I mean, do you have special rules for people who don't have insurance? Do you have special rules for people whose insurance won't pay for more than one MRI a year or one, X number of visits a year? They just feel like, okay, we have to feel like there's got to be some threshold. Is the threshold too demanding? I think it may be, but this is the world we have to live in. So, Jim, what you're talking about is the inherent unfairness of the Social Security disability process, and it's right up there with 2-year delays and consultative doctors who spend 15 minutes with you and use the same report over and over. It's right up there with adjudicators who are sitting on files for 8 or 10 months. I mean, it's not a particularly fair system. It's a huge bureaucracy. There's really no accountability. And many adjudicators like Linda, and there are some that do a really good job. But there are some consultative doctors like John Foster, who I've had on here before, that do a good job, I think. But not everybody does. So it can be a real challenge. But if you're asking me, Jim, is the system unfair? Many times, unfortunately, it is. And we have to just deal with we have to deal with what the evidence we can get is, and that can be a real challenge. Look, it would be nice if I could afford to spend $500 to $800 to send a client out to a medical orthopedist for an independent medical exam. I can't do that because I have no way of getting my money back. Medical, in personal injury practice, very common. An attorney sends the client out for an independent medical exam, absorbs the cost of an MRI, and then gets paid back later. We can't do that. So, it does limit us in some respects. So you just got to deal with what you got to deal with, and I hope you get a reasonable judge. And like I said, if somebody, and Social Security feels this way too, I think if you are, really, really not well, you're going to find a way to get to the doctor in some way, shape, or form. And someone's got to be creative about it. And I'm not being flippant about that. I'm just saying that's what they think. So that's what we got to deal with. Christy, how do I think he's doing? I don't really have an opinion. I mean, what she's talking about is he's also on a committee at the IRS. The only thing I know about him is that he was, I think, president of FinServe, which is a big finance company. He's a big believer in artificial intelligence and automation. I think that, in private industry, he has more resources at his disposal. He can move things quicker. I don't think he's nearly as friendly to claimants as Martin O'Malley was, the commissioner last year. Um, I think it's kind of too early to tell with Bisignano what he's going to do. Um, I know that some of the people at NOSCR have had meetings with him. They say he's pleasant. They say he seems open, but he has to report to the people that hired him, and they're probably not all that supportive of claimants in the disability process. So, he may not be able to do what he wants to do. He may have to satisfy the requirements of the administration and what their priorities are. So it's kind of early to tell. But again, what I've heard, excuse me, is that he is trying to be hands-on. I see, photos of him visiting field offices, and people that have met him say he's a nice person, but whether, he can bring order to this chaos, I don't know. It bothers me, says SA, that SSA may request medical records from a neurologist right for seeing him, but before he has a chance to know me. Yeah, I think that, those initial records are part of your file. I'd rather them get the records sooner rather than later, but yeah, you want to have a complete picture. And you're right that a doctor who's seen you for 6 months or a year is going to have a better sense of what's going on than the doctor is going to know after the first visit. But they're going to get the records when they get the records. If anything, it's been more of a problem that they wait or they don't get the record, soon enough. It's rare that they get them too soon, but it can happen, I guess. Yes, Jennifer. No, Jennifer, I know that I don't like to. I'm always very aware of my client's privacy, and so unless they've identified themselves as my client, I don't like to say that. But yes, I know. And I will just say this: I take cases that I can win because I don't get paid otherwise, quite frankly. And I try to take sometimes challenging cases, but most of the cases I take are pretty strong. And as you point out, 7 surgeries in 3 years. Well, we got a pretty good argument, I believe. So let me see if we have a hearing date yet. I think we do. Let's just take a look. December, yes, we do have a hearing. And we have a judge with a higher than average approval rate. So I think I've been before this judge here. I don't remember exactly, but higher than average approval rate. So I think we're in pretty good shape. Absolutely. Yeah, 63%. You can't go wrong with that. That's pretty good. Pretty good. D. Finney. Yes, been in contact. Madeline is one of my assistants. My name's in the form. Yes, absolutely. I'm the only attorney who does Social Security in my office. So yes, I will be your attorney. I am your attorney. Again, we have a system in place where I have to use people because I'm very fortunate. I got to tell you, I get a lot of calls and emails, and so I have people that I work with that screen them because otherwise get nothing else done. So their job is to, and what we do is, just so you know how I do at my office is, I get leads that come in throughout the day, typically by email. I look at them, the ones I feel like this is someone that has potential. I will send it to Madeline or Darlene or Angela and say, okay, here are the questions I want you to ask. This is what I need to know. And they've been doing this long enough where they kind of know what I'm looking for. And, then once the forms get filled back, then I look at it and kind of, go over and make sure everything is where I want it to be. But we have a pretty good system. And so, yes, you're in that process at this point. But I will be handling your case, yes. And Jennifer, I know this has been a long road, and we're getting close. December is coming up. We're getting close. So we got 6 weeks. We'll be, I think, ready to go. I believe we're going to be in good shape. Recently got approved. The field office can't find my file. I've had this happen a few times. Other offices can see it. What can I do? You need to contact your U.S. Senator's office and just say exactly what you told me. I've been approved. They're saying I can't find my file. It can be seen online. Get this unstuck. This is a red tape problem. Contact your senator. This may be where this shutdown could be a problem because, um, I have heard that some of the senators' offices, their staff, may be part of what's being cut. So, but I would still reach out to your senator's office. That's how to unstick this. Dreamers Club. So my ALJ had a little approval rating. You won. Took 5 weeks, but she approved me. So yes, absolutely, absolutely can happen. Yeah, and again, you mentioned this before about ALJ didn't mention anything about medications. Taking 15 medications does not mean you're disabled, but if you have evidence that these medications are sedating or causing mental confusion, and I have literally done this. Where if I have people that are on a lot of medications, I'll print out the side effects from, I'll go to drugs.com or there's, other places you can go where you can get printouts of the side effects. And, I'll show the dosage is this. This is the side effects that are typical. This is what my client's complaining of. Get that in the record. That's something you can do. And I've done that before. Somebody's on, high dose of gabapentin, for example. You know, and most judges know what gabapentin does, but I'll print out the gabapentin fact sheet from drugs.com, at this dosage, and mental confusion is very, very common, fuzzy thinking, whatever they call it. And that becomes part of the record. And that makes the judge, so, you're basically saying, here's evidence of what this drug does, and makes it hard for the judge to ignore that. So yeah, that's how we do it. JMac, 49 years old, hearing a February MRI says severe stenosis, 2 bulgy discs, Walker prescribed, all very helpful things. Did PT, chiropractic, major depressive being 49.5. Yeah, it's a good case. The risk is that if you turn 50 before your hearing, that the judge says, okay, I'm going to approve you at age 50. On the other hand, when you're using a walker, that's a pretty significant problem. Severe stenosis, a reasonable judge would say you don't have to be 50 for that to be disabling. Other judges are going to say, yeah, I'll approve you at 50. It just depends on your judge. But I think it's a pretty good case, all that. Hey, Steph, how are you doing? Stephanie is here, or she's watching, which I appreciate. And I know you've had a long day. You told me had a long day, but I'm glad you tuned in. And we'll get you back on when you next time you want to come on. You let me know. I'm glad I had a chance to meet your audience, and of course, you're always welcome to meet mine. And we had a nice chat. We had some interesting discussions about things, and it's nice to bounce ideas. Steph has done this a long time, like me, and we will bounce ideas off each other at times, whether by phone or Zoom or by email. And it's good to have people like that because, we all have different experiences, and you never know when you pick up something, one little thing, you realize, hey, this could be a really valuable tool. And look, I honestly, I get sometimes some of my best ideas from hearing decisions. I mentioned the borderline age situation. It was mentioned in a decision. I'll admit, I didn't really know what it was. I don't remember. It's been several years, but I had a decision where a judge mentioned, I'm like, well, borderline age. I never really thought about that, but yeah, that we can use that. So now that's in my quiver. So if I have a person who's 54 and a half or 54 and 10 months, I'll say, hey, let's use the borderline age. And, more often than not, it works. So, I think one of the things that you pick up when you do this for a while, little tips here, little tips there. I refer to the PALMS regulation about transferability of skills. That is something I have on my desk I use that a lot because what that basically says is that if you're age 55 and limited to sedentary, age 60 limited to light, when Social Security considers transferability of skills, they have to use a standard of minimal vocational adjustment, which means it's really hard to find another job that you could do. That's a valuable tool. That's a law that really helps us. That's something that it's a really big deal. Steph, we were talking today on her live stream about the change in the past work, past relevant work look back was 15 years. Now it's 5 years. I regularly look, I will tell you, at state agency decisions, meaning when I'm looking at a file, the state agency, Social Security, has made a decision, and they denied you, of course, otherwise it wouldn't be at a hearing. And I look at the part where they talk about past work, and they're looking at past work from 10 years ago, 15 years ago. They just screwed up. Somebody at the state agency doesn't know you can only look at the last 5 years. So if they found, and I've put this in briefs before, I've seen situations where they found that a claimant could do past work that was done 8 years ago, 10 years ago, but they couldn't do the work that was done within the last 5 years. So in my brief, like, okay, the state agency said that you could do the claimant could do past relevant work. However, they referred to a job that's no longer past relevant work. Therefore, there is no past work, or the state agency acknowledged that the person can't do past work. Therefore, we satisfy step 4 of the sequential evaluation process, and we eliminate the question of whether they could do past work. Now the burden of proof shifts to Social Security to prove there's other jobs they could do. And I know it sounds kind of like a lot of legal mumbo jumbo. It's important. That's something that can be very, very helpful to get you approved. But, you can't assume because the state agency made a finding that their analysis is correct. They'll put on there that such diabetes is not a severe impairment, but you're on insulin and you've got, episodes of diabetic ketoacidosis. Well, that is a severe impairment. We have to go and we argue against it. So, you have to really read through all this stuff. And I think we were talking about this before. Sometimes what's missing is as important or more important than what's there. Sometimes you just have to realize something doesn't make sense here. Why is what's missing here? Like somebody put, on a question, they didn't talk about medication side effects. Well, that's missing, but that can be very relevant. And, in an appeal, if you've been denied a hearing, that would be something you put in appeal. They didn't consider that. The judge did not include that in his functional capacity question or his hypothetical question, and that's reversible error. So that's being aware what's not there as much as what's being aware there. So that's why it's so important to have a network of people like Stephanie and I have with each other, and there are other attorneys out there who, that we all both talk to, and somebody like Adriana, who I read her LinkedIn post or have her come on here, because you pick up little things, and 1 or 2 little things can make the difference in whether you win or lose. JMax says, my claim has been going on since September of 2003. You mean 23 or 3? 2003 would be a long time, so that seems unlikely. Maybe you meant 2023. But do they want people to give up? Yeah, they do. I mean, I had Spencer Bishens on. Spencer is a former Social Security decision writer, and his opinion was that is part of the process. They want people to give up. That's a little cynical, but maybe he's right. I don't know. Ken says, thank you. My pleasure, Ken. Killer of demons. Lost your hearing because the judge found disability wasn't severe, plus it had substantial gain from employment, which is BS from appealing. Okay. Yeah, I mean, I think that, that's what you want to do when you appeal. And, some judges just don't see it your way. And again, it's not enough just that you disagree with the opinion. You got to show why. But you have MRIs and that was not considered. Yeah, that could be certainly very helpful. We got about 15 more minutes here, so we'll take as many questions as we can get. Okay. Cajun Sunshine. Do you think it'll be much longer if you hear anything? We've been at a year. This is unfortunately becoming more and more common. Yes, we should hear something. Now we're at 14 months. Email me tomorrow and let me see what I can find for you, just to see what's going on. I know that Jen checks it periodically, but let me check it myself. So just email me if you don't mind tomorrow, and I'll check for you to see what's going on. Rip DT Tina. Rip DT Tinea. Thank you. You're welcome. La Lulu's agreed. Happy evening. Great. Thank you. Fantastic to see spaces. Okay, Corinder, I don't know what that means. Fantastic to see spaces. Okay, not sure what that means. Have you had no cases in Jacksonville? Yeah, I just had one a couple of days ago. Percentage of approval, it depends on the judge. I don't know I could look it up, the hearing office in Jacksonville. Let me see if I can do that really quick while we're online here. And I can tell you, let me see if this will let me do it. Let me just do search for Jacksonville. Okay, Jacksonville, all judges, according to this website I'm looking at, for 25 is a 43% approval rate. Let me show you what I'm looking at, okay? Let me just show you. Might be easier to do it that way. All right, let me share my screen, and I'll give you the, I'm going to put the link in the comment section here. I'll show you what I just did here. Let's see if I can do this. Share screen. Share screen is, okay, right here. So I'm going to this website, and I go to, this is a Statsis O'Brien and Filer's website, thanks to them. And I just go over here and type in Jacksonville. And what comes back is it gives me all the judges in Jacksonville. So we've got one judge here at 25%. We've got one judge at 61%. We've got one judge at here. So you've got, it ranges 35, 52, 50. So you can sort of see the average is 43. So I would say, unless you get this judge at 26%, or maybe the judge at 35%, you're in pretty good shape. I had a case with Judge Greer, which I believe is going to get approved recently. He's 47%. I've had a case with Judge Koster. He approved it. Landro, I've had cases with many of these judges. So that's where I'm looking. You see the win versus losses percentage. I think the awards is really going to tell you what percentage they're awarding there. So, or high of denials. So, and again, like the judge here with low approval, he's denying 55%. So that says to me that 60 or 45% of the cases are being dismissed or approved. So a 55% denial does not, that is actually better news to me, because his approval rate's low because there's a certain number of dismissals there. And dismissals would happen if somebody doesn't show up at the hearing, or they don't, fill in the form properly, whatever. The case just gets dismissed. So of the ones he's denying, the ones he's approving, really more accurate, it looks like he's approving about 45% of the cases that he's actually listening to. It seems to me, because if he's denying 55 approximately, then 45 would be the ones that are being approved. So it doesn't look like a bad office is what I'm getting at. So, and again, I can see several of these names look familiar to me. So I've tried cases and won with many of them. At one point, I will tell you, there was a judge, I don't remember his name, this is going back a number of years, who was notorious for being a very low approval judge and being a real SOB. He appears to be gone, but there was at one point a judge who was not very nice at all. But it looks like it's pretty reasonable now. Corinder, navigating Social Security can be complex. Absolutely, absolutely. He's talking about what attorneys do. Yeah, I think that you want to make sure that you speak their language. And I always tell people that, I mentioned to Stephanie today on her live stream, that Social Security, she was laughing when I said this, it's like a different universe with different laws of physics. It is a completely different world. You'd think that logically, you would think logically the federal government has 4 or 5 disability programs. The VA, the FERS, the this, the that, the railroad, all have different standards of disability. Does that make any sense to anybody? Why you'd have the same government having different types of disability with different standards? It makes no sense. You know, the notion of disability being focused on vocational capacity as opposed to medical. The VA bases it on medical. Why does Social Security base it on vocational? Why do they use a 30-year out-of-date resource? It's a different universe, folks, is what I'm going to tell you. And so what we do as attorneys is, we are your astronaut guide to this alternate universe. And as ridiculous as some of these things are, you have to know how the system works. You can't go in there and say, this is unfair. I know I'm disabled. Anybody can tell, pay me. Can't do that. You got to play their game. And so that's what we try to do. But I think Corinder is making a good point. You have to have a guide, and at least at a hearing, I would say. Maybe beforehand you can muddle through, but at a hearing, you don't want to do that by yourself. And I'm telling you, as an attorney, I realize that's how I make my money. I'm just telling you, whether you don't hire me at all, get an attorney. Don't do a hearing by yourself. Okay, great. Thank you, Corinder. I appreciate your comments. Yes, Pricey Joy is correct. Don't volunteer stuff. You never want to volunteer anything. Ask, answer the questions that's asked. Do not volunteer things that are not asked. If the judge doesn't ask you about your use of marijuana, don't start talking about marijuana. If the judge doesn't ask you about, part-time work you did or the fact that you're, a dog sitter, don't answer it. If you have an 85-pound dog and the judge says, you watch your dog, your answer is yes, not yes, I watch an 85-pound dog. Because that's going to raise other questions. Well, how do you deal with an 85-pound dog? How do you walk an 85-pound dog? Wouldn't that pull on your back? If they don't ask, don't volunteer. Real simple. That's lawyering 101. If they ask you what you did on Monday, they ask you what you did on Wednesday, don't talk about Tuesday. This is, while it's not adversarial, you have to be smart. There's enough things in the deck is stacked against you enough where don't volunteer things that are going to hurt you. And if you're not sure what to talk about, ask your attorney. I tell my clients, and any of them that are on here that have had cases that I've tried will tell you this. I even did a video about this. I will be rude to you. I will cut you off. I will tell you to stop rambling. Not in so many words. I try to be pleasant about it, but I had a pre-hearing call this week, and my client says, I get really nervous. I start talking a lot. I said, don't worry. If you start to ramble, you start to blab about things that are irrelevant, something happened 25 years ago, I'll cut you off. He goes, that's great. Perfect. I want you to. That's what I will do. That's what an attorney does as well. You have to realize if you're losing the judge, if you're starting to talk about things that are not relevant, and you're getting the judge upset because you're wasting his or her time, you got to step in and say, okay, I appreciate that you fell off a hayride in high school, and that's probably where your back problem started. The issue is you went to work for 30 years after that. Let's talk about, I'm not going to say it that way, but I realize that this may be the genesis of your problem. Let's talk about what's going on since the 6 months before you stopped working to the present. What's going on? That's what the judge is going to find relevant. And that's what you got to do. That's what you have to do, is to really focus on what the judge is going to find relevant. Thank you, Corinder. I appreciate that very much for your kind words. How do they verify marriage? If an American citizen is married overseas but lives in the USA, I've seen them ask for marriage certificates. Rare, but I've seen them ask for it. And I don't know that marriage is really all that relevant unless it's an SSI claim where you may have, the deeming issue, but otherwise it's really not all that relevant. Okay. Very good. I'm glad we can clear it up. Okay. Yeah, that may be something we can talk about. What we might want to do is make a list of all the medications you've tried. And again, this is something that it's kind of crystallized in my mind as somebody asked that question. Maybe we should do that. We should make a list of all your medications and the dates you took them, and put this on a form 795 and talk about why you have treatment-resistant depression. I think that would be a really good idea. So again, let's send me an email. Let's talk about that next day or so and see if we can't make that happen, because I think that's actually a really, really good idea. I think it's a really good idea. I think it really help our case. if I get a long form, how do I ensure they get what they need in a timely fashion, giving the providers a little heads up? I mean, fill out the form. It's not hard to fill out. I think the main thing you can do is they'll get the medical records. So what I would do is make sure you have current addresses. I would call your medical providers and say, what address should I use to get medical records? Social Security may be asking for medical records. What is the address they should send it to? And I think if you do that and you provide that to Social Security, that really increases the chances they're going to get your medical records. And you could also, of course, tell them Social Security is going to be asking for these things, but make sure that Social Security has the right address. Let them do the work. Let them do the work. Okay. What kind of medical documentation are considered strongest for SSD claims, and how an attorney can help make sure it's submitted? Okay. Clearly, the most compelling evidence is going to be objective test results like MRIs, CTs, ultrasounds, pulmonary function tests, things like that, because that is objective. If you have a herniated disc, you have an MRI, that's going to show it. So I think that's objective tests are the gold standard if you can get them for your condition. The second thing would be a doctor who will discuss your functional issues, a doctor who knows you, who can intelligently discuss your functional issues. And by that, I mean fill out a functional capacity evaluation, or at least to address what they call it as a medical source statement, the issues you might have with various tasks. If it's physical, sitting, standing, walking, lifting, kneeling, stooping, crouching, crawling, bending, twisting, overhead reaching, foot controls, things like that. If it's mental, attention, concentration, focus, persistence, pace, behaving in an emotionally stable manner, getting through the day without distraction, interacting with coworkers, supervisors, the general public. These are all in functional capacity forms, and they're available free online. So I think that, if you can get those from your doctor, that goes a long way. Then, of course, treatment records. If you have ongoing treatment records, you're basically showing Social Security, this is not a short-term problem. I've been struggling with this for years. And the doctors have tried various things, whether it's procedures or medications, and it's not really resolving the problem. That's the way you want to approach it. That's what the medical. And so, what I do at the initial recon is, or my staff does, is we provide all of the information, all the contact information for the medical providers so they can get that. Let them get it. Let them do that's their job, to get those medical records. And as Linda told us a couple of weeks ago, they want to do that. They want to get the records. They feel like they're accurate at that point. Then what I do as the attorney is I look to see what they've got. And if they and Linda said in her situation, and I believe her because I've had this happen, they'll call me. I have a direct number that Social Security, I give to Social Security to contact me. They will call me and say, we're having trouble getting records from Dr. Smith. Can you help us? And I will. If they let me know they're having trouble, I'll go to the portal. I'll have my client go to Dr. Smith and say, you got to give us those records. I'll call Dr. Smith's office and say, what's the problem? And let Social Security know. So that's kind of what you got to do. And then, at the initial recon, most of the time nowadays, Social Security gets the records, they upload them. If it's a HIT facility on the Health Information Technology database, they get it automatically. If I have to get them through a portal or through other records, or maybe some clients has a photocopy of an old MRI, I will upload them directly. I have electronic access to your folder. I will upload them directly. It doesn't go to a fax machine in Kentucky where it hopefully gets associated. I upload them directly. So that's what I do to make sure it's to the right place. So that's the way I approach it. Okay. This is Pricey George's comment about whether SSDI is enough to live on. This is not a Heineken bottle. This is a Maison Perrier. This is bubble water, soda water. I get them at Costco, buy them in bulk. I happen to, it used to be, and I'm getting low on time. I'll just go tell you this quick story. Is I used to drink a lot of Coca-Cola, a lot of soda, Dr. Pepper, Coca-Cola, because you have the caffeine, gives you a little bit of boost. It's liquid sugar. It's really not good for you. So about 7 or 8 years ago, I just went cold turkey. No more soda water, no more soda for me. I'm just not drinking it. I immediately lost like 15 pounds. I mean, it was just empty calories. And so what I do is I buy, this, or you can go to Publix and get for $1.50 a liter, 2 liters of club soda, or you can get Soda Stream and make your own if you don't mind the loud noise. I just go to Costco and buy this, and I'll take some real lemon or real lemon juice or lime juice, and I'll just put a few drops in there, and so it gives me a little bit of flavor. And this is as satisfying to me as soda was. Doesn't have the caffeine kick. I don't really like caffeine. I'm real sensitive to it. If I drink caffeine after noon, it keeps me up at night. But if you are a soda person, I would tell you a real nice alternative is to get these, soda, like I said, whether it's Costco or get Publix or make your own or whatever. Put a little lemon juice, a little lime juice in there, and it will save you all those calories, those empty calories, because soda, as delicious as it is just deadly. It's empty calories. You're drinking, sugar. It's just not good for you. And, if you're in the disability world, you want to do everything to make your health better. Coca-Cola ain't it. Or Pepsi-Cola or any soda is not it. So, but this is not Heineken. I don't like beer. I have no problem with it. I just don't really like it, unless every once in a while, like a dry beer I can take, like a Japanese beer, but I don't really like the taste of it. I'm from Atlanta, and of course up at UGA, University of Georgia, beer is a big deal. I just never liked it. I don't drink. I really am not a drinker. I mean, some people like a cocktail, just not me. Just never really have liked it. So my vice is M&Ms, dark chocolate, popcorn. That's my vices food wise, but pizza maybe, but soda, club soda or soda water is my what I recommend to drink. Okay, a couple more, then we'll go. Yes, just Mary, what you do is you would need to fill out the form, and you can see the link down here, and just make a note on there that you mentioned that, and we typically call. I mean, I need to have the email, so I have your contact information and a little bit about your case, but I'll make sure somebody gets back with you by phone. All right. Let's see here. Let me just put this in here. First of all, I do have a new Instagram channel. So if you are inclined, if you're on Instagram, I have several people on the live stream subscribe. So please check me out on Instagram, just Instagram Ginsberg Law Offices. Check me out there. I'm putting more of the short form videos on there, but I'm trying to build it. So please, if you can help me. And then if you are happy with what you're seeing here, leave me a review. There's a link down here. Leave me a review. And of course, reach out to me if you need a case evaluation. Pardon me. That's one problem with soda water. Gives you a little bit, it makes you burp a little bit. Okay, let me go through a couple more here. Okay, well, I'll answer this question. Mistakes in their application. Can you give examples of common errors? Yes. The most common error I see, bar none, is I can't lift very much. I can't walk very far. I don't do much at all. Those don't mean anything. So if they say, how much can you lift? 5 pounds, 10 pounds. How far can you walk? 10 minutes, 30 yards. You got to be specific. That is the biggest mistake I see. The second mistake I see is underestimating the numbers. So for example, how much in your past, there's a job report. How much did you have to lift on your past job? I'll see people put, 20 pounds max. When I'm talking to them, oh no, it was 45 pounds. Put it, think about that. When you put on how much you had to lift at your job, even if you had to do it once every 3 weeks, that is part of your job. Even if you didn't really lift much at all, but that was part of your job description, you had to have the capacity, put it on there, because judges look at those forms, that work report form, the one where you detail what you did, how much standing and walking and lifting and so forth. If you did more than 3 hours of walking, that moves you into a light category, which is, more, it makes it easier to win than if you're just sedentary. So, those are the sort of things that really can make a big difference. I'm really going to do a video on that. I think that that form in particular I'm seeing is really important to me, and I'm using it a lot in my hearing. So I'm going to do a video on that one. So we'll do a screen capture video about the work report form. You'll see what I'm talking about. But yeah, I think that just being specific is the biggest issue, and answering the questions and really thinking about it. Because look, for example, you ask somebody, how much can you lift? I don't know. I mean, you ask me, how much can I lift? I haven't measured. I mean, I know I have a weight bench here, and there's a deadlift that I can lift. I have 50-pound weights on it. It's one of those hex bars. So I know I can lift from the ground 100 pounds or 120 pounds with the hex bar. So I can do that. But if I didn't have that hex bar, I wouldn't know. If somebody says, well, what is 10 pounds? Well, a gallon of milk's 8 pounds. Imagine having a gallon of milk in both hands. That's 16 pounds and walking around with that. Can you do that? If it's unwieldy, it's not, it's, let's say it's a, it's a, I don't know, a chair or something that's not, compact, you can hold against you. Can you really lift a 15-pound chair? That's something you got to think about. And again, when I'm talking to my clients, I'm saying, okay, imagine you've got a gallon of water, a gallon of milk in both hands, and you're walking from here to your mailbox and back, okay, which is what you might do, in a job equivalent. Could you do that? I don't think I could do that. Well, that's, then that says your work lifting capacity is less than 15 pounds. You might have thought it was 20, but realistically it's less than that. Frequently means 2/3 of the day. Occasionally is 1/3 of the day. So can you lift 15 pounds frequently? Can you spend, in your day, 4 or 5 hours, consistently lifting a gallon of milk with both hands? That's if you think about it, that's a lot of weight. So those are the questions I'm saying. Is you got people who are just they understate what they can do, or they overstate their capacity. Probably a better way to put it. They say they can do more than they think they really can. But their biggest thing is they're just so vague. I can't do very much. And I'll add to this, in my opinion, if you can do it, type it out. Go online, get the form, and type it in, as opposed to handwriting. Social Security is using a lot of OCR, optical character recognition, and certainly AI uses that. Handwriting is hard to read. So if you can't type and you can't get somebody to type it for you, get somebody with really neat handwriting to do it. I can't tell you how many times looking at forms and I can't read them. Nobody can read them. The judge can't read them. And, that doesn't help anything. But I think the biggest thing is being specific, I would say. Okay. All right, let's do a couple more questions. We'll call it a night because we're already at 2 hours. I was informed my case was decided and pulled for a federal quality review. It's random. I don't think that's a bad or good sign. I think it's random. Hello, Mrs. K. Okay, let's make 2 more here. Mary, what would you recommend a disabled person who went 900? I want more, 415, a divorce, more money from without a review, so I received it. Okay, Mary, I'm sorry, I don't understand that question. I know there's some typos in there. I'm going to have to pass on that. I don't know. Darlene, yes, she is great. Darlene is a treasure in my office. Very happy to have her. Okay. All right, we'll leave with this one. Hi, old Ag 99 plus. Thank you. Watch my video. When my video here. Okay, excellent. That's a great way to leave. My pleasure. I'm glad you got benefit out of them. That's why I do these. Really trying to share what I know, as does Stephanie. You just want to make sure that you help, people to, this is sort of, it's a black box in a lot of respects. And, you try to help as many people as you can. Obviously, I like when people become my clients, but it's also quite rewarding. I get letters and postcards, letters from people like this. I won my case. And that's cool as well. You know what? I mean, I think that, you want to, hopefully it sounds kind of hokey, but, good karma, send good stuff out, it comes back. So try to do that a little bit. So anyway, I hope that was all helpful. I'm going to run now because we've been at 2 hours. I need my beauty sleep, as you can probably well tell. I've got a hearing tomorrow I want to get ready for. I got a lot of work to do and want to get to it in the morning. So I'm going to close out now. Thanks again for coming. Next week, I'll be here. I may start a little later next week have a friend of mine who is turning 80, which is kind of cool. And they're having a little party for him, and I'm going to go. It's at 6:30. So I may, I want to make sure I get back in time. So rather than 8:30, I may start at 8:45 or 9. I'll put it out there, but I'll be here next week regardless. So anyway, hope everybody has a good evening. Stay warm, and we'll see you next week. Thanks a lot.